My sister is the sole beneficiary. The lawyer didn't hesitate when she said it. She didn't soften her voice. She didn't look at me first. She read it straight from the page and kept going, already moving to the next clause. I stopped breathing. Across the desk, Vanessa didn't react, didn't look surprised, didn't look confused. She just sat there, hands folded, exactly where someone sits when they already know what's coming. I interrupted and asked the lawyer to read my name again. The attorney paused, checked the document, and said, "This is the most recent will. Filed 18 months ago." And in that moment, before grief could even catch up, I understood something irreversible had already been done, quietly, legally, and without me in the room. I asked to see the document. Ms. Rothman hesitated, then slid it toward me. I scanned the pages, looking for my name, for the provisions my father and I had discussed years ago when my mother passed. The house was supposed to be split evenly. The land was supposed to go to me. He'd said that. Multiple times. But the will in front of me told a different story. The house went entirely to Vanessa. The land went to Vanessa. The savings account, the one he'd been contributing to for 30 years, went to Vanessa. I received a single item. A vintage watch. Appraised value, $800. I looked at my sister. She was staring at her hands, not meeting my eyes. And I understood immediately. This wasn't an oversight. This wasn't my father changing his mind in his final months. This was something else. Something deliberate. Something that had been happening while I was working 60-hour weeks 2 states away, believing everything was fine. I asked Ms. Rothman when the previous version had been written. She checked her files. 4 years ago, she said. Would you like to see it? I said yes. And when she handed me that earlier document, I saw my name everywhere. Equal distribution. Fair division. Exactly what he'd promised. Then I asked the question that changed everything. What happened 18 months ago? Ms. Rothman explained that my father had come in to revise the will. That he'd been accompanied by Vanessa. That the changes were made over 2 appointments, both of which Vanessa attended. I felt my throat tighten. Not from grief. From recognition. 18 months ago, my father's health had started declining. Small things at first. Forgetting appointments. Repeating himself. Confusion about dates. I'd noticed during our phone calls, but Vanessa had reassured me it was normal aging. Nothing to worry about. She was living 10 minutes away. Checking on him daily. Helping with bills, groceries, medical appointments. Being the good daughter. The one who stayed close while I'd moved away for work. I'd been grateful. Relieved, even. I'd thought she was taking care of him. Now, sitting in that office, I realized what had actually been happening. She hadn't been taking care of him. She'd been positioning herself. And I'd been too far away to see it. I looked at Vanessa. Still silent. Still staring down. And I made a decision. I wasn't going to argue. I wasn't going to cry or accuse or make a scene in a lawyer's office. I was going to do something else. Something she wouldn't expect. I was going to let the system ask the questions I couldn't. Let me tell you who I actually am. My name is Morgan Ashford. I'm 36 years old. For the past decade, I've worked in medical research, which required me to relocate twice for career advancement. My father understood. He supported those moves. Told me he was proud. Told me not to worry about him because Vanessa was nearby. And I believed him. Because my father wasn't the type to lie. He was careful. Deliberate. Someone who planned things years in advance and stuck to his word. The first will, the one written 4 years ago, reflected that. Equal treatment. Fair division. The kind of document someone writes when they're thinking clearly and want to avoid conflict after they're gone. But the second will, the one written 18 months ago when his cognition was already slipping, told a different story. It gave everything to the daughter who was present. Who controlled access. Who sat in on legal appointments and medical consultations. Who answered his phone and managed his calendar. The contrast was so stark it should have been obvious. But grief makes you doubt yourself. Makes you wonder if you misunderstood. If you're being selfish. If you're imagining malice where there was only circumstance. So I didn't challenge it that day. I just asked Ms. Rothman if I could have copies of both wills. She agreed. And I walked out of that office with 2 documents that told 2 completely different stories. I didn't confront Vanessa immediately. I went back to my hotel room and sat with the documents for hours. Reading them side by side. Comparing dates. Looking for patterns. The first will was straightforward. Clear. Specific. It outlined exactly what went to whom and why. My father had even included notes explaining certain decisions. The land goes to Morgan because she's always loved that property. The house is split equally because both daughters contributed to its upkeep over the years. The second will had no explanations. No notes. Just allocations. And every allocation favored Vanessa. I pulled out my phone and started going through old messages. Texts from my father over the past 2 years. And I found something I hadn't noticed before. Around 18 months ago, his messages changed. They got shorter. Less detailed. More generic. And increasingly, when I'd text him directly, Vanessa would respond. Dad's resting. I'll have him call you later. Dad's at a doctor's appointment. I'll update you after. Dad's not feeling well. I'll let you know if anything changes. At the time, I thought she was being helpful. Now I saw it differently. She'd been managing his communication. Controlling who he spoke to and when. And in doing so, she'd created space to rewrite his intentions without me knowing. I hired my own attorney 3 days later. Not for a will contest. Not yet. Just for consultation. I needed to understand what was legally possible before I decided how to proceed. The attorney, a probate specialist named Andrew Carr, reviewed both wills carefully. Then he asked me a series of questions. Did your father have a diagnosis of cognitive decline? I said I didn't know. Vanessa had mentioned some memory issues, but nothing formal. Had he been evaluated by a neurologist? Again, I didn't know. Vanessa had handled all his medical appointments. Did you have any communication with him directly during the period when the second will was drafted? I checked my phone. A few texts. 2 brief calls. Both times, he'd seemed distracted. Tired. Not entirely himself. But nothing alarming enough to make me fly home. Andrew leaned back in his chair. Then he said something that changed my entire approach. If your father lacked capacity when the second will was signed, it can be challenged. But you'll need medical records. Documentation. Proof that his cognitive state was compromised. I asked how I'd get those records. He said I'd need to request them from his physicians. But there was a complication. Vanessa, as the executor named in the current will, had legal access to everything. I didn't. Not unless I contested. Which meant going public. Filing paperwork. Making accusations. Turning this into a fight. Or, Andrew said slowly, you could wait. See what she does next. Because if she tries to liquidate assets quickly or hide documentation, that creates a different kind of evidence. I understood what he wasn't saying directly. Let her move first. Let her think she's won. And document everything she does wrong. I didn't tell Vanessa I'd hired an attorney. I didn't tell her I was questioning the will. I just stayed quiet. Attended the probate hearings. Signed the documents I was required to sign. Played the role of the grieving daughter who was too overwhelmed to think about money or property or legal details. And I watched. Vanessa moved quickly. Within 3 weeks of the will being read, she listed the house for sale. Didn't ask me if I wanted to keep it. Didn't offer me the chance to buy out her share. Just hired a realtor and put it on the market at a price that would guarantee a fast sale. Then she contacted the county about transferring the deed for the land upstate. Started the process of putting it in her name alone. Every action was legal. Technically. She was the executor. She had the authority. But the speed was notable. The lack of communication was notable. The way she avoided my calls and responded to texts with brief, formal language was notable. And I documented all of it. Saved every message. Recorded every date. Built a timeline that showed not just what she was doing, but how quickly she was trying to finish it. Because speed, I was learning, often indicates fear. And fear indicates something worth hiding. For weeks after the reading of the will, I received a call from my father's primary care physician. Not his office. Him directly. He said he'd heard about my father's passing and wanted to express his condolences. Then he said something unexpected. I wanted you to know that I'd recommended a full cognitive evaluation last year. Your father seemed open to it, but the appointment was cancelled. I asked who cancelled it. He checked his notes. Your sister called. Said your father had decided it wasn't necessary. I thanked him and ended the call. Then I sat very still, processing what I'd just learned. My father had been advised to get a cognitive evaluation. Had apparently agreed. And Vanessa had cancelled it. Which meant she'd known. She'd known his cognition was declining. She'd known a formal diagnosis might complicate her plans. And she'd intervened. Not to protect him. To protect her access. I called Andrew immediately. Told him what the doctor had said. He was quiet for a moment. Then he asked if I'd be willing to request my father's complete medical records. I said yes. He walked me through the process. How to file the request. What to ask for. How to frame it as a daughter seeking to understand her father's final months rather than as someone building a legal case. The records arrived 2 weeks later. And what they showed was worse than I'd imagined. The medical records painted a clear picture. Starting 2 years ago, my father's doctor had noted mild cognitive impairment. Recommended monitoring. Suggested a neurologist consultation. By 18 months ago, the notes showed increased confusion. Difficulty managing finances. Short-term memory loss. And a recommendation, written clearly in the chart, for a formal capacity evaluation before making any major legal or financial decisions. That recommendation was dated 2 weeks before the second will was signed. I made copies of everything. Organized them chronologically. Cross-referenced them with the dates Vanessa had taken him to revise the will. The overlap was impossible to ignore. His doctor was recommending a capacity evaluation. Vanessa was taking him to a lawyer. And somehow, the will got changed in her favor right in the window when his ability to make informed decisions was most compromised. I sent everything to Andrew. He reviewed it carefully. Then he called me. This is enough, he said. You have grounds to challenge the will based on lack of capacity and undue influence. I asked what undue influence meant legally. He explained. It's when someone in a position of trust uses that position to manipulate a vulnerable person's decisions for their own benefit. Isolation, controlling access to information, making decisions during periods of confusion. All of it applies here. I asked what came next. He said we'd file a petition with the probate court. Present the medical records. Argue that the second will didn't reflect my father's true intentions. And let the court decide. I agreed. Not because I wanted a fight, but because staying silent would mean accepting a lie. We filed the petition 6 weeks after my father's death. The document was careful. Factual. It didn't accuse Vanessa of anything criminal. It simply presented the timeline. The medical records showing cognitive decline. The doctor's recommendation for evaluation. The cancellation of that evaluation. The timing of the will change. And the rapid liquidation of assets after his death. We requested that the court review both wills, assess the circumstances under which the second will was created, and determine whether my father had the capacity to make those changes knowingly and voluntarily. Vanessa's attorney responded within days. They called the petition baseless. Said my father had been of sound mind. Said the changes reflected his genuine wishes. Said I was motivated by greed, not justice. The language was sharp. Defensive. Which told me something important. They were worried. Because if they weren't, the response would have been calmer. More dismissive. The aggression meant they knew the medical records were a problem. And aggression, in legal proceedings, often backfires. The court scheduled a hearing. Both sides would present evidence. Medical experts would be called. The attorney who drafted the second will would testify about my father's state of mind during those appointments. And the judge would decide which version of my father's intentions was real. The hearing took place 3 months after I filed the petition. I sat on one side of the courtroom. Vanessa sat on the other. We hadn't spoken directly since the lawyer's office. All communication had gone through attorneys. Cold. Formal. Irreversible. My attorney presented the medical records first. The progression of cognitive decline. The doctor's notes recommending evaluation. The cancelled appointment. The timeline showing that the will was changed during the exact period when my father's decision-making capacity was most questionable. Then he called my father's primary care physician as a witness. The doctor testified that he'd expressed concerns about my father's ability to manage complex decisions. That he'd recommended a capacity evaluation specifically because legal and financial matters were becoming difficult for him to process. That the cancellation of that evaluation had surprised him. Vanessa's attorney cross-examined. Asked if the doctor had ever officially declared my father incompetent. The doctor said no. Asked if my father could still have lucid moments. The doctor said yes. But then my attorney asked one follow-up question. In your medical opinion, during the period when the second will was signed, would you have recommended that my father make major legal decisions without a formal capacity evaluation? The doctor paused. Then he said, no. I would not have recommended that. Next, we called the attorney who had drafted the second will. Ms. Rothman. She testified that my father had come to her office twice. That Vanessa had accompanied him both times. That he'd seemed tired but coherent. That he'd expressed a desire to leave more to Vanessa because she'd been taking care of him. My attorney asked if she'd conducted any capacity assessment. She said it wasn't standard practice unless there were obvious signs of impairment. He asked if she'd been aware of my father's medical recommendations. She said no. She hadn't requested medical records. He asked if Vanessa had been present during the actual signing. She said yes. He let that answer sit for a moment. Then he asked one more question. In your experience, is it common for one beneficiary to be present during the drafting and signing of a will that heavily favors them? Ms. Rothman hesitated. Then she said quietly, "It can raise questions about undue influence." The courtroom went silent. Because that statement, from the attorney who drafted the will, carried weight. She wasn't accusing Vanessa directly. But she was acknowledging that the circumstances were unusual. And in legal proceedings, unusual circumstances require scrutiny. Vanessa's attorney tried to recover. Called character witnesses. Friends who testified that Vanessa had been devoted to our father. That she'd sacrificed her own time and resources to care for him. That the will reflected his gratitude, not manipulation. And all of that was true. On the surface. But my attorney didn't challenge their character testimony. He just asked each witness a simple question. During the time you observed Vanessa caring for your father, did you ever see Morgan? Most said no. One said once, maybe twice. He asked if they knew why. They said I lived far away. He asked if anyone had told them I'd offered to help. To visit more. To contribute financially to his care. No one knew. Because Vanessa had controlled that narrative too. She told people I was too busy. Too focused on my career. Too distant. And without access to me, they'd believed her. The judge asked if I wanted to testify. My attorney said yes. I stood. Walked to the witness stand. And for the first time in months, I spoke directly about what had happened. Not emotionally. Not angrily. Just factually. I explained that I'd called my father regularly. That Vanessa had increasingly answered his phone. That I'd offered to visit, to help, to hire professional care, and been told it wasn't necessary. That I'd trusted her. And that I hadn't known about the cognitive decline until after he died. I didn't cry. I didn't accuse. I just stated what had happened. And when I finished, the judge asked Vanessa's attorney if they had any questions. They didn't. The judge took 2 weeks to issue a ruling. When it came, it was procedural. Calm. Institutional. The court found that the medical evidence supported significant cognitive decline during the period when the second will was drafted. That the timing of the will change, combined with the cancelled capacity evaluation and Vanessa's presence during the legal appointments, raised sufficient questions about undue influence. The second will was invalidated. The first will, the one written 4 years earlier when my father's cognition was clear, was reinstated as the controlling document. Everything reverted. The house would be sold and the proceeds split evenly. The land would go to me. The savings would be divided according to the original provisions. Vanessa would have to return anything she'd already liquidated. The ruling didn't call her a thief. Didn't accuse her of elder abuse. Didn't assign moral blame. It just said the second will didn't meet the legal standard for validity. And because it didn't, it couldn't stand. I read the decision alone in my apartment. And I felt something I hadn't felt in months. Not victory. Not satisfaction. Just clarity. The system had worked. Not because I'd argued loudly. But because the records had spoken clearly. Vanessa didn't appeal. Her attorney advised against it. The medical evidence was too strong. The timeline too clear. Fighting further would only cost money and yield the same result. So she complied. Returned the funds she'd withdrawn. Stopped the sale of the house. Transferred the land deed back. We divided everything according to the original will. Fairly. Equally. The way my father had intended before his mind began to slip. We never spoke about what had happened. No apologies. No explanations. No acknowledgement of the manipulation or the betrayal. Just lawyers and documents and legal processes that separated us permanently. I sold my half of the house 6 months later. Kept the land. It sits upstate, undeveloped, exactly the way my father left it. I visit once a year. Not out of sentimentality. Just to remember. To remind myself what almost got taken. And what I got back by refusing to stay silent. People ask if I regret going to court. If it was worth the time, the money, the family fracture. I tell them the truth. I didn't go to court to punish Vanessa. I went to court because the system could ask questions I couldn't. Could demand answers she wouldn't give me. Could examine evidence that exposed what really happened. And once that evidence was examined, the truth didn't need defending. Looking back, I understand what happened more clearly now. Vanessa didn't set out to steal. She set out to be rewarded. For years, she'd been the daughter who stayed close. Who helped. Who sacrificed. And she believed that entitled her to more. When my father's cognition declined, she saw an opportunity. Not to hurt him. But to formalize what she felt she'd already earned. The problem was, she crossed a line. She didn't just care for him. She controlled him. She didn't just help him make decisions. She made them for him. And when his doctor recommended a capacity evaluation that might have complicated her plans, she canceled it. Not because she thought she was doing something wrong. But because she thought she was doing something right. That's what made it so dangerous. She justified every action. Every cancelled appointment. Every intercepted phone call. Every legal revision. Because in her mind, she deserved it. But deserving something doesn't make it legal. And the law doesn't care about justification when capacity and undue influence are at play. The court didn't rule against her because she was a bad person. It ruled against her because the process was compromised. And compromised processes, no matter how well-intentioned, don't produce valid results. I left that experience with something unexpected. Not bitterness. Not anger. But a deep understanding of how systems work. And how they fail. The medical system failed when it recommended an evaluation but didn't follow up to ensure it happened. The legal system almost failed when it accepted a will revision without verifying capacity. The family system failed when distance and trust allowed one person to control an entire narrative. But the one thing that didn't fail was documentation. Medical records that showed what my father's doctor had seen and recommended. Legal records that showed when decisions were made and who was present. Communication records that showed how access had been managed and controlled. Those records didn't argue. Didn't get emotional. Didn't take sides. They just existed. Clear. Dated. Undeniable. And when the court examined them, the truth became obvious. I carry that lesson with me now. In every professional relationship. Every family decision. Every situation where intentions could be misrepresented later. I document. Not because I distrust people. But because I trust systems. And systems need evidence. 3 years later, I ran into Vanessa at a mutual friend's wedding. We hadn't communicated since the probate case closed. Hadn't been in the same room. Hadn't acknowledged each other's existence. But there we were. Seated at different tables. Watching the same ceremony. When the reception started, she approached me. Asked if we could talk. I said yes. We stepped outside. She didn't apologize. Didn't try to explain or justify what had happened. She just said one thing. I thought I was doing the right thing. I looked at her for a long moment. Then I said something I'd been thinking for years. I know you did. And that was the problem. We stood there in silence. Then she nodded once and walked back inside. That was the last time we spoke. Not because of anger. Not because of resentment. But because there was nothing left to say. The court had already said it. The records had already said it. And no conversation we could have would change what had already been decided. Some betrayals don't end with reconciliation. They end with clarity. And clarity, I'd learned, was enough. I think about my father sometimes. About what he would have wanted. And I believe he would have wanted fairness. He was someone who valued balance. Who believed in equal treatment. Who planned carefully to avoid exactly the kind of conflict that erupted after his death. The first will reflected that. The second will didn't. Not because he stopped loving me. Not because he suddenly decided Vanessa deserved everything. But because his ability to express his true intentions had been compromised. And someone he trusted used that vulnerability. The court understood that. Even if Vanessa never did. That's why I don't feel guilty about challenging the will. Why I don't regret the legal fight. Why I'd do it again if I had to. Because fighting wasn't about money. It was about honoring what my father actually wanted when his mind was clear. When he could think. When he could plan. When he could choose freely. That version of his intentions mattered. And it deserved to be protected. Even if it meant going to court. Even if it meant fracturing what was left of a family. Even if it meant becoming the daughter who sued her sister. If you're listening to this and something feels familiar, if you've watched someone close to an aging parent slowly take control, if you've been told everything's fine while being kept at arm's length, I want you to know something. Trust your instincts. If communication patterns change, if access becomes restricted, if decisions are being made without you, those are not coincidences. They're strategies. And they're often legal. Right up until they're not. The line between caregiving and control is thin. And it's easy to cross when no one's watching. So watch. Ask questions. Request medical records. Talk to doctors directly. Stay involved even when it's inconvenient. Even when you're told it's not necessary. Because by the time you realize something's wrong, the decisions may already be made. The wills may already be changed. The assets may already be moved. And reversing it requires exactly what I had to do. Evidence. Documentation. Legal intervention. And a willingness to make family conflict public. It's hard. It's expensive. It's emotionally exhausting. But sometimes it's the only way to protect someone who can't protect themselves anymore. The land upstate sits quiet now. Undeveloped. Untouched. Exactly how my father left it. I go there once a year, in late summer, when the trees are full and the air smells like pine and earth. I walk the property line. Sit on the old stone wall he built decades ago. And I think about what almost got lost. Not just the land. But his intentions. His clarity. His careful planning. The version of him that existed before confusion set in. That version mattered. And it deserved to be honored. The court agreed. Not because I argued emotionally. Not because I made a compelling case about fairness or family. But because the medical records showed cognitive decline. Because the timeline showed suspicious timing. Because the evidence, when examined, told a story Vanessa couldn't talk over. That's the power of documentation. It doesn't need passion. It doesn't need persuasion. It just needs to exist. And when it does, the truth speaks quietly. Clearly. Finally. If this story resonates with you, if you've ever watched a family member's intentions get rewritten by someone who controlled access, I want to hear from you. Leave a comment below. Tell me where you're listening from. Tell me if you've faced something similar. Because these stories matter. Not just as warnings. But as proof that the system can work when you give it the right evidence. That documentation outlasts manipulation. That courts can distinguish between genuine care and undue influence when the records are clear. Subscribe if you want more stories like this. Stories about family betrayal. About legal justice. About what happens when the overlooked stop accepting narratives and start building cases. Because the world is full of people who believe good intentions justify questionable actions. But it's also full of records. Medical charts. Legal timelines. Communication logs. And when those records enter a courtroom, intentions don't matter. Only evidence does. My sister thought she was doing the right thing. The medical records said otherwise. And in the end, the records won.